Sara Carter joins us, investigative reporter, Fox News contributor, David Schoen, civil liberties and criminal defense attorney, Greg Jarrett, Fox News analyst. Welcome all of you to the program. Let's start with, if I can, with you, Greg. Jeff Sessions now urging Mueller to wrap up this investigation. It's about time.
Oh, it's totally about time. There was never a scintilla of evidence that anybody in the Trump campaign colluded with Russians to fix the election, to win it for Donald Trump. There was never a legal basis justified under the federal regulations to launch the investigation, including, now we know, there was no evidence of intelligence to justify the counterintelligence process. So the whole thing.
Well, hang on one second. So I've just confirmed that the text messages, the latest batch of struck page messages, have now been delivered to the congressional committees. All right. So that means whatever redactions that needed to take place have taken place. And that would mean we'll probably get them certainly by Hannity tonight at 9. Sorry about that.
Well, you know, these text messages will probably reveal even more evidence that people at the FBI were politically motivated to clear Hillary Clinton and frame Donald Trump. That's the story of the hoax.
Let me go to David. David, what you have been very strong in your opinions about the president ever talking to Robert Mueller. Giuliani, apparently, it was reported earlier in the week that he had opened the door in terms of new negotiations with Robert Mueller and his team. What do you make of that Daily Mail article?
I'm not sure what to make. I don't know how much is posturing and how much is the truth. I reiterate exactly what you said. That is, any criminal defense lawyer worth his or her salt would never permit the president to sit down with Robert Mueller because of Mueller's agenda. But
he called the investigation a disgrace, quote unquote.
And why dignify it then with the president of the United States sitting down with him? Listen, there's a mechanism through the special counsel regulations in which Mueller is to be giving regular notification, regular reports to the Justice Department. In this case, Mr. Rosenstein. We don't know if that's happening. We don't know. But any significant event is to be reported. As you've said many, many times, where's the evidence? We certainly haven't seen anything. But it is past time to wrap it up. We need to get on with the business of the country. There are pressing events around the world.
There really are, and we have the opportunity nobody thought possible, the denuclearization of the Korean Peninsula, then, of course, this emerging alliance between the United States, Israel, the Saudis, Jordanians, Egyptians, the Emirates. Sara, you've been pretty much parked out at Congress waiting for these new text messages. They have now finally been delivered to the congressional committees. I'm assuming we will see them shortly.
Yes, this was news that we've heard all morning that they were going to be delivered. Of course, we expected them to be delivered yesterday, and they weren't. So now that they are delivered to Congress, remember these text messages are redacted. The unredacted version, I am told, can be viewed in camera. That means at the DOJ by congressional investigators. So that's going to be a back and forth. If the congressional investigators want to view the full text messages without any redactions, they will have to go over to the DOJ in order to view those. But right now, they did deliver the redacted version.
Do we know how many that they delivered now? Because, and this is the sad part, the DOJ slow walking again because they had them last week and didn't tell anybody.
That's right. So Congressman Mark Meadows, as well as Chairman Devin Nunes, Ron DeSantis and Trey Gowdy, among others, were very upset about the fact that the Department of Justice did have these text messages, which were delivered by Michael Horowitz with the DOJ, in his investigation to them last week. They were very angry that they did not have those text messages and really have been battling behind the scenes to get them. And so it appears that there'll be thousands of text messages. I'm not quite sure how many of those. You mentioned 50,000. That is a number that Attorney General Jeff Sessions threw out in January. So how many of those they delivered, we're not sure yet. I'm assuming it's all of the text messages that were missing from December 2016 until May 2017. And remember, Sean, it was the FBI and the DOJ that said they couldn't get those messages, that there was a technical glitch and they had disappeared. They would never get them back. And then the Inspector General sent out his investigators. They got a hold of the Samsung phones, and they were able to retrieve what some intelligence officials told me were ghost texts. So they were able to pull them directly from the phones. That's what their IT personnel did. So this is going to be very interesting because this is the most important time of the investigations.
Let's go to all the criminal referrals to our two lawyer friends here, and Greg, we'll start with you. We had the congressional criminal referrals to the Justice Department last week, and that included everybody: Hillary, Strzok, Page, Orr, Comey, Mueller, Rosenstein, or maybe Rosenstein, I don't remember. Definitely McCabe. Then you had McCabe also getting an IG criminal referral. Now we've got an investigation into the former FBI director, James Comey. Are all of these people, are all of them potentially in legal jeopardy today?
They all are, and I would put James Comey at the top. Obstruction of justice, theft of government property, mishandling classified documents under the Espionage Act, and now, most recently, false and misleading statements to Congress, because we're just now learning that it wasn't just Richmond that he gave classified information to, but Patrick Fitzgerald. He didn't disclose that to Congress.
And maybe even one more person we hear.
Yes. And look, when you are testifying before Congress, if you conceal information, that's considered a material omission. That's a false statement. It's a crime. And I think there's,
in other words,
Inspector General is looking at that.
Because you don't give specific information, you only gave selective information. I only leaked to this one guy when he leaked to at least two, maybe three people. It's sort of like the omission, putting an asterisk in the FISA application. Well, it may have political implications when you know darn well it was Hillary who put it together.
Exactly. And for example, when he identified Richmond as his friend, a professor, he did not disclose that he was actually a special employee of the FBI. That is a material omission. That's a crime.
All right, we're going to keep all of you now for the full hour, and we may even get a few calls in here as well if people have questions or comments. We'll have more on the Cosby verdict, guilty on all charges. 800-941-SEAN is our number.
For freedom.
Sarah, at the bottom of the hour, Greg and David are going to stay with us. Sarah.
Yes, I was very interested in what he had to say, and I do think Anderson Cooper asked really significant questions right there because he kind of caught Comey off guard. I don't think he was expecting Anderson to be so tough on him. And Anderson, and Comey conflicted when he was making these statements. I think one of the really important questions here, and we have to ask ourselves, is why didn't Comey, and I would have liked him to have asked this, why didn't you just tell Congress? If you were so concerned about President Trump, and you wrote these memos, and apparently you didn't write any memos on Obama or Hillary. You were so concerned when Congress asked you these questions about, did you ever feel pressured or anything like of that nature? Why didn't he just come out and say it? Why the runaround? Why did he go ahead and, leak these memos to his, because it was a leak them to his friend, Dr. Richmond, and then have him deliver it to the New York Times? I mean, he didn't have to do that. He should have just come forward.
All right, Sarah's now going to go get a hold of those Strzok Page memos. We'll have them tonight on Hannity. Thank you, Sarah. David Schoen and Greg Jarrett, stay with us. And your calls, 800-941-SEAN. All right, 25 now till the top of the hour. 800-941-SEAN, our toll-free telephone number. You want to be a part of the program. The guilty verdict all across all three charges as three counts as it relates to Bill Cosby. And if, in fact, the sentencing happens, he could face, if it's consecutively, 30 years in jail. He's 80 years old, meaning he would die in prison. Concurrently, well, even then, it depends how many years he ultimately serves. Of course, his defense is saying that they are going to appeal that verdict. But we continue. A lot of big news happening as it relates to after a meeting with Mueller, Giuliani, in a WMR interview called Mueller's Investigation a Disgrace. Jeff Sessions, the Attorney General now, is literally asking Mueller it's time to wrap up this investigation. really good piece by Victor Davis Hanson I haven't gotten to yet, but we continue with attorneys David Schoen, criminal and civil liberties attorney, and Greg Jarrett, Fox News legal analyst. What's the name of your book again? Because I always forget.
It's called The Russia Hoax, the illicit scheme to clear Hillary Clinton and frame Donald Trump.
And when is this book coming out? Because Greg's office is 2 doors down from mine at Fox, and I see you've been pounding away on that computer for a long time now.
Well, it's now in the hands of the publisher. It's completely written. They're going through editing. And you can be pre-ordered on Barnes & Noble or Amazon. Just go to their websites. It comes out in a couple of months.
Yeah, we're looking forward to it. What happened today as it relates to in court that went on earlier today, where a special master was appointed? And in other words, the federal judge handed down this ruling in this case involving Michael Cohen. What does that mean? A special master.
Go ahead.
A special master is what we've called for on this show since the start of that case. At least I have, because it's vitally important. This has been put in place in the Southern District of New York in the past. Nothing special for Michael Cohen. It's a vitally important step so that a third party, a neutral third party from the outside, not the government team, not a taint team, not a privileged team from the government, reviews all of the records that were seized from Michael Cohen so that a neutral person can take input from the lawyer himself as to what would be privileged and what should be turned over, that sort of thing. It's vitally important. And that's the process that the judge first balked at. It should have been in place from the start. And for example, in another case in the Southern District, in the Lynn Stewart case, the judge prohibited any government lawyer from looking at any document that was seized. And by the way, the agents who go in can't be involved with the investigation. They prohibited anyone from looking at it. They had to be sealed in a vault, and only the defense lawyer whose records were seized and the third-party special master could have access to them.
Does that mean only things that would be relevant to a case that are not attorney-client would be used then?
Only non-attorney-client privileged documents should be seen by anybody other than the attorney and now the special master. And it's a long culling process to go through. And frankly, clients need to have input into that also, which is, the other reason I said from the start that President Trump needed to have a representative in there, which he has now, to protect his privilege. It's got nothing to do with holding lawyers, giving lawyers more say in the process. It's about protecting clients' rights, and everyone in this country is a potential client at some time. The right is a cherished one.
What does that mean to you, Greg, and what does it mean for things that are not connected in any way to whatever they're looking into?
Well, my concern is that government officials have already looked at the documents, and to some extent they had to, in order to be responsive to the search warrant and seize relevant material. They had to eyeball some stuff, including material on computers. And this is why there should have been a special master that went along on the search and seizure.
Would that be the normal procedure, that the person would go along when it actually happens?
Well, it has certainly been done on many occasions, especially when you're talking about breaching the attorney-client privilege.
Right. That's right. Right.
Well, what does it mean that this recommendation actually came from Mueller with the approval of Rosenstein to the Southern District of New York, which has a reputation of being a very tough, if you will, office?
Well, it certainly means that it has nothing whatsoever to do with collusion or obstruction of justice, because otherwise Mueller would have handled it himself. They saw something else that they thought was suspicious that has nothing to do with the current special counsel probe, and so they referred it to the U.S. attorney.
What's your take, David?
I think it's also the process not working. Remember, the only way Mueller can venture into an area is if the deputy AG, in this case Rosenstein, authorizes it. Again, this thing can go on forever and ever. And remember, one of the main dangers of the regulations under the special counsel statute is that Mueller is able to charge people with crimes all along the way. If he thinks someone didn't tell him the truth and is getting in his way, he can charge that person unilaterally with a crime. It's a very abusive set of regulations if one wants to abuse them.
Yeah. Let's walk through. For example, what does it mean, if anything, that in fact Jeff Sessions is urging Mueller to wrap this up? Greg.
It probably means that he knows, as Rosenstein probably knows, that there's no there. There's no crime called collusion. Comey tried to spin it last night, collaborating with a foreign
well, actually,
government.
he actually said there is no crime as collusion. We just played that.
Yes, but then he said, but it could be conspiracy with a foreign government to defraud the United States. If you look closely at that statute, it is inapplicable to the facts of this case, because I've studied it. And so, there's no evidence of collusion, never was. And you cannot question the President of the United States about his constitutional power to fire somebody in the case of James Comey. And finally, as to Michael Flynn, hoping and wishing that he's cleared, take a look at the presidential memos, the March memo in particular, in which the president asks Comey to continue to investigate as to whether anybody colluded with Russia.
Well, he said even people associated with him, that we need to keep going.
Right. So he wanted to continue all investigations until, he got to the bottom of it.
It's amazing, because I thought that was that's the smoking gun in terms of exculpatory evidence against any case of obstruction. Is it not, David?
Yes, it is. And I want to say though, talking about Mr. Comey, he emphasized the word you mentioned a second ago. He said no crime like collusion, but there is conspiracy. That's the government's favorite tool. It's very broad. I think he better be careful, because depending on what happens with these memos, some of his friends may well be dragged into what he might call a conspiracy. But I have to get back to your point about wrapping up the investigation. You have Mr. Giuliani, who's a fan of Mr. Mueller's, saying it's a disgrace. Now, that's each person who's encountered someone with this investigation that it's a disgrace, it should be stopped. But what about the irony, though, of Congress now trying to pass this Mueller protection bill? And what's driving me crazy is senators like Senator Grassley, Senator Graham, talking about a constitutional crisis if the president were to fire Mr. Mueller.
How many times does the president have to say there's no intention of firing Mueller?
But either way, it's simply not a constitutional crisis. It's the Constitution working. That's the power.
But the president, wouldn't the president under Article 2 have the authority to do that?
Absolutely, and it's built into the regulations, which, by the way, were promulgated in the Clinton administration in 1999 and sold to Congress by Eric Holder and Janet Reno, Neil Katyal, on the idea that the president will have the ultimate authority. While the member of the Justice Department has to do the firing itself, the president has the authority under Article 2 to make that decision. That's working. Congress has the ability to make their own investigation, to bring impeachment proceedings if that's what they think is appropriate. But this is the Constitution working if he fires Mueller or Rosenstein. It's built in, and it was intentionally built into the regulations by President Clinton.
Is there any legal culpability, Greg Jarrett, for Patrick Fitzgerald or this Professor Richmond over at Columbia University, or maybe I keep hearing that there is perhaps a third person that got a hold of these Comey memos? Are they on the receiving end of this in any trouble?
They could be, depending upon the content of the information and documents they retained. Now, remember, the FBI went to Daniel Richman's office and seized material there to contain the leak of classified information.
You said this on TV last night. I did not recall that ever happening or making big news. Why didn't that make big news?
Well, it was in the New York Times, I can tell you that much, over the weekend. But they buried
that's
it.
why I missed it. Because
they buried it on a back page at the bottom of the story, which is classic New York Times.
Wow.
Bury the lead.
If it was any Republican, it would have been splashed top fold of the front page.
Absolutely. And a source who's very reliable tells me the FBI went to Fitzgerald's office to do the same thing. It's called spillage cleanup. And if you think that classified information is getting out, you try to contain it.
Who would have made that? Who would have ordered that?
Well, that's a very good question. The FBI has advised Senator Grassley that they believe that classified information made its way into the hands of unauthorized individual. I assume that's Daniel Richman and perhaps Patrick Fitzgerald.
Is Comey being too cute by half hiring the two people that he leaked to?
Oh, he's totally doing it to hide behind the attorney-client privilege. It's a Machiavellian move by Comey, and it's classic Comey. As I said on your program last night, Comey makes J. Edgar Hoover look like a Boy Scout. That's how manipulative and exploitive Comey is.
Yeah,
there's a very specific problem with if Mr. I don't know that he is. If Mr. Comey is going to claim attorney-client privilege with Daniel Richman, he's got a big problem. We have a lot of unanswered questions about Daniel Richman's special governmental employee status. When was it? Did it meet the parameters, etc.? But if he were a special governmental employee, he was the employee of the agency or the department, the executive branch, not Mr. Comey's. He doesn't share privilege with Mr. Comey, and the regulations then would prevent him from appearing in the matter as a private lawyer in a matter that he was involved with as a special governmental employee. Now, Comey has said apparently that he gave him the documents in his role as a special governmental employee to advise him, although he told him to leak it. He can't be both. The guidelines prohibit it. It's actually a crime if a lawyer, for example, were to try to enter a matter that he had been involved with as a government employee, or in this case, even as a special governmental employee. That's 18 U.S.C. 202 and 205.
Mm-hmm. Let me ask both of you a quick question, changing gears here. Bill Cosby convicted on all three counts of aggravated indecent assault. Each count has or carries with it a potential for a $25,000 fine and 10 years in prison. And if they were served consecutively, he's 80 years old, he would certainly die in prison. Greg.
Well, they'll do a pre-sentencing report. It's going to take a couple of months, and then there'll be a sentencing hearing, I suspect, at the time that Tom Mesereau, who's Cosby's attorney, who I went to law school with, he will make the case that instead of sentencing, it ought to be held in abeyance while Mesereau appeals. Mm-hmm. Cosby will probably be confined to his home.
And if, in fact, if there's a victim impact statement, I would imagine that's going to be compelling. David Schoen.
Sure, that's where the judge came down in this case. Listen, they had a mistrial the last time around. The judge made some evidentiary decisions that are going to be a subject of the appeal. But the two biggest ones were he let 5 other victims, purported victims, come in and testify. They'll be in the victim impact statement also. And he allowed in evidence.
Was that the right decision considering the statute of limitations had passed?
It's a very tough call. The general rule is prior bad acts don't come in unless they're independently relevant. He found that they were independently relevant. But what about the settlement? The idea that Bill Cosby paid over $3 million, that was probably the death knell in this case, on a gut level for most jurors. So the judge put a pretty heavy hand on this thing the second time around.
All right, thank you both.
And that will be the basis of the appeal right there.
All right, we'll have a lot more on this, and we're awaiting Strzok and Page memorandum. The text message is coming out. Thank you, David Schoen. Thank you, Greg.